And we now are particularly grateful for Roper Cleland, who's come to us today, and really is one of the few panelists that comes from directly the private sector and the experience of the private sector of trying to ensure that human rights are embedded in their business operations. And Roper is the Senior Manager on Social Responsibility for IPIECA, which is the Global Oil and Gas Industries Association on Environmental and Social Issues. So Roper is going to speak to us directly about community grievance mechanisms for human rights, that issue around are the fast ways in which we can actually achieve those, that redress and that access to justice. Thank you very much.
Great, thanks Phil. And good job on pronouncing IPIECA. It's always a mystery to many people on how to pronounce it. And I was also pleased to hear a question already from participants about non-judicial mechanisms, and I hope I can share a little bit more about, from an industry perspective, what we see as good practice and some of the lessons that we've learned through a project that we've been doing. So IPIECA deals with environmental and social issues for the oil and gas industry. And over the last 3 years, we have had a project looking at implementation of the UN Guiding Principles and working out what that means in practice for companies. In addition to a piece on human rights due diligence and human rights impact assessments, which I won't go into today, we're also doing a lot of work on community grievance mechanisms and leading a collaborative learning project to test implementation of them on the ground and produce a series of tools, templates, and guidance materials to enable companies in the implementation of them. Community grievance mechanisms are part of the access to remedy expectations as defined in the UN Guiding Principles. And the purpose of them is to enable companies and those impacted by operations to resolve issues in a non-judicial manner. So it's important to emphasize that they cannot replace, nor should they impede access to judicial systems or prevent claimants from going to court. However, we do believe that they offer a strong alternative in cases where effective communities have little confidence in a judicial system or little ability to access it. And in addition to this, community grievance mechanisms we believe to be very cost-effective and efficient way of resolving potential conflicts to satisfaction of companies and complainants, particularly before those potential conflicts can escalate. And if access remedy is visualized as a continuum of solutions, grievance mechanisms fall on one end of the scale where they can benefit communities by offering solutions that are consensual, low cost, and I think that's an important one. We've discussed today some of the barriers due to costs in the legal system. Also that they're beneficial to many rather than few. They're less adversarial, and they can enable coming to mutually agreed reparations, which can be financial, but importantly, as well as we've discussed, can often be non-financial as well. The pilot project we have been running, we have had 7 member companies of IPIECA nominate to either set up or refine a grievance mechanism at an operational level. And the companies participating vary very much in size and experience. And the projects themselves span 3 different continents, both North America, South America, and Africa, and both onshore and offshore operations. And the offshore piece is particularly interesting from an oil and gas perspective because there can often be an assumption that just because you don't have an immediate geographic community in an area of operation, that there are no community impacts. So it was very important for us to have something in an offshore facility as well. It also includes both conventional and unconventional assets, and in developing and developed countries. And the companies participating have conducted pilots to an agreed framework so that we can have that collaborative learning fed back upwards to the entire IPIECA membership and also in the development of our tools and guidance materials. We are also working with consultants with significant experience and specialist knowledge with the oil and gas industry and in community consultation. And the project takes into account the specific expectations of the UN Guiding Principles around community grievance mechanisms, which are that they are legitimate, accessible, predictable, equitable, transparent, rights compatible, a source of continuous learning, and based on engagement and dialogue. But these really say, the guiding principles really say what a grievance mechanism should look like. It doesn't say how. So this is really an opportunity for us as IPIECA to work with industry to define that. And our experience indicates so far that grievance mechanisms should be risk-based and responsive to local need and circumstance, rather than following a detailed prescriptive or one-size-fits-all solution. However, I would still stress that the basic principles as set out in the UN Guiding Principles do apply to any grievance mechanism. However, you tailor that depending on the local need and circumstance. Another learning that we've come to through the project is that the vast majority of community grievances against companies can be solved amicably, particularly if they are addressed before they become acute. And I think time is a really important element of grievance mechanisms. This is really an opportunity to take in some preventive measures so that those impacts on communities do not worsen. And it also undermines our belief that grievance mechanisms should be part of a comprehensive stakeholder engagement process. So yes, they relate to human rights, but they also relate to what companies do in terms of their more generalized stakeholder and community engagement procedures. And if a grievance mechanism is the only channel of communication a community has with a company, everything's going to come through it. So alone, a grievance mechanism is not enough. It needs to be part of a wider stakeholder engagement process. And it will also make that process much more robust, so it works both ways. Another finding is that addressing grievances early and promptly helps companies avoid the escalation of issues, as I've mentioned. And it can ensure that there's not worsening relationships, so there's a strong business case for companies here as well. And this ties in with John Ruggi's findings on a trip, one of his field visits, where a community member said the company wasn't listening to us when we had small problems, so we decided to make a big problem for them. So again, it comes into that preventative measure and to ensure that these are addressed up front. Also, of course, it's very important to be able to measure the success of a mechanism. This requires good KPIs and sound data analysis. And important indicators we found through the project are measuring the number of repeat grievances, satisfaction with the process, also satisfaction with the outcome, and the length of time to close grievances. And a particularly strong one is when a claimant is not satisfied with the outcome but does indicate they're satisfied with the process, because that would suggest that they felt like they were treated in a fair, equitable, and transparent manner. So that goes back to the effectiveness criteria set out in the guiding principles. And we would strongly dissuade against measuring success in terms of no grievances or few grievances, because that would also indicate that probably communities either don't know about the mechanism, can't access it, or don't trust it. So it would suggest that the effectiveness criteria are not being met. And another learning is that resolving an issue is about maintaining the relationship. It's not about companies seeking a win at all costs. These are relationship building tools designed to build and maintain confidence in a company, as well as about resolving the complaints and concerns and impacts by community members. For example, in a case where a complaint is reviewed and found to be invalid, sharing the feedback to the complainant is still very important because it can demonstrate a company's respect and responsiveness to local concerns. So in terms of conclusions, It is critical to design a fit-for-purpose mechanism, ensuring that it's risk-based, and you can only do this by engaging a broad range of internal and external stakeholders in its design and implementation. And that a grievance mechanism should be part of a business's risk management by preventing, minimizing, and alleviating community opposition. There is a strong business case for companies to do this because it can prevent them from facing a range of obstacles, such as delays in permits, unplanned costs, personnel and site security problems, and reputational damage, in addition to addressing impacts before they become acute. There may be instances, as I said at the beginning, where it is necessary or desirable to use state-based mechanisms. However, we do strongly believe that non-state remedies may offer much scope in practice to improve outcomes for communities and companies. For example, where complaints are confirmed and require some form of remedy, companies may be able to provide remedies promptly without the complainant having to spend a lot of time and money on a legal process, should they not wish to. Finally, we also are very excited about the project because we believe that this is an opportunity to demonstrate that IPIECA and its members take a very serious approach and to the remedy expectations of the guiding principles. And to this point, we make all the outputs available on our website. We aim to promote good practice across the whole industry. So I would encourage you, if you're interested, to please access our materials. We have a grievance mechanisms toolbox available, and at the end of the year, we'll be publishing our final findings and guidance materials on the project. So I'll leave it there, but I hope you have some questions for me as well. Thank you.